So this is kind of new and different for me. I'm actually up here. As you guys know, I've been kind of keeping the event going on and the program going on. But what you might not know is that I'm a two-term elected official in the village of Mamaroneck. I sit on the Board of Trustees. We have a village of over 19,000 people. And that is the role that I am in right now, in that capacity, in moderating this particular panel, because we are going to be talking about zoning, jurisdictions, and rights of way. You know, a lot of issues and concerns in deploying solutions have to do with what do you need to get done from a planning and permitting standpoint, what are concerns from an environmental standpoint, and what are the legal and FCC requirements that we need to account for. And so I have a panel here of esteemed specialists who will introduce themselves, and we'll have an interesting discussion, I can guarantee that, about all of these issues. So we'll start right now with Marvin on the end here.
I'm Marvin Webster. I'm with Environmental Corporation of America, and for about since 1992, I've been involved with just about every aspect of National Environmental Policy Act and National Historic Preservation Act, also environmental permitting for wireless facilities. When I talk about NEPA and NHPA or National Historic Preservation Act, that's principally environmental issues and historical resource issues for wireless facilities.
I'm sorry, excuse me, just before we go to Lino, if anybody can make sure that the doors are closed, that would be very much appreciated. Thank you very much for that. Lino, go ahead.
Good afternoon. My name is Lino Sciarretta. I'm a partner at the law firm Wilson, Elser, Moskowitz, Edelman, and Dicker. In my background, I specialize in representing municipalities as either town or village attorney or special counsel with respect to land use, zoning applications. And incidentally, I was village attorney in the village of Mamaroneck for a few years, so familiar with the zoning process and the planning process with respect to wireless telecom.
David Bronston. I'm a special counsel at Phillips, Lytle, and I specialize in telecommunications infrastructure. I say to my daughter, until they put the chips in our head, the infrastructure, the equipment has to go somewhere, and that somewhere is somebody's property. And it's either personal property or public property, the only two types of property. And there's a transaction there, and that's where I get involved, whether it's permitting or the actual agreement, that intersection of real estate and telecom.
Thank you. That's great. Thanks. So I'm going to start with Lino. What does the process actually look like? You know, if you're a provider and you're coming into a municipality, what does that look like?
Well, what I tell my clients and municipalities that I do work for, I would treat a cellular application, a wireless application, really like a site plan with the exception of the timing requirements, which are much more expedited when processing a wireless application. So with respect to timing, I always tell my board members to keep the timing in mind, especially with respect to co-location, with respect to the processing of the application, because a lot of these times the board members, they think of it, yes, as just another planning application, but they have to realize that there are timeframes and constraints. They shouldn't be delaying, and that's what I like to focus on with respect to these applications when they come before my boards, is expediting the process and get it through quickly.
So from my experience, anyhow, as a trustee, a lot of the public concerns have to do with, you know, not just the process. You know, they actually don't really care so much about the process. What they care about how it will affect them, and in particular, environmental concerns. And so I know, you know, we're lucky to have Marvin here up on the panel. How can we demystify these environmental concerns that residents tend to have about bringing cellular services into villages, towns, and cities? Well,
you know, federal agencies, FCC being one of those, have a process where the federal agency has to consider the environmental and cultural resource consequences of an action. And as far as demystifying, you have residents who essentially don't want to look at these facilities. They want all the benefits. And so the opposition, if you will tend to latch on to environmental and historic resource concerns as a way of throwing a stumbling block in the way of deployment of facilities, when it may not be the environmental or the cultural historic preservation aspect that they're necessarily opposed to. It's just a good way to, it's a lever to use to pull things in your direction if you're opposed to facilities.
So we've got the perspective of, the village, town, city, what they're looking for and how they can work through the process. We got residential concerns, right? Or, end users and, constituent concerns from an environmental perspective. So what's in it for the providers?
Well, we have to build out. We are required under our, the carriers are required under their federal licenses to build out and serve the public. So this is a necessity. The good thing is that I think the regulatory wind is at the carrier's back now, going back to, in 2012, the Middle Class Tax Relief Act passed what's called Section 6409, and then in 2013, I was at the NEDAS event in Washington, spoke about the FCC coming out with a notice of proposed rulemaking, spoke again the last year in 2014, the rules were coming out, and now, speaking here in 2015, the rules go into effect literally next week. And what those rules do is make co-locations, modifications, the need to swap out equipment go much, much quicker. And I think the localities actually appreciate that, even though they're suing actually to stop the rules. They appreciate that there are bright line rules that they can go to their constituencies and say, look, these are the rules, we have to follow them. The rules make clear that a substantial change, more height, defeating the stealthing, more protrusion, excavation, those are substantial changes that do not go through a as of right, if you would, permitting that has a 60-day clock on it.
And so how are village planning boards and zoning boards and all those types of boards, how are they getting educated, and how are they going to be able to respond to this type of requirement, a new ordinance, and put that into play?
When people like David come before our boards, it's a pretty easy thing to do because, I'd say, maybe 5 years ago, you'd still have people come out, talk about RF emissions and things that we kept telling the public, listen, you can ask for this kind of information with respect to make sure they comply, but you can't deny an application based on that. They're preempted. So what's happening, what I've seen, is carriers now much more sophisticated coming before the boards, and they make my job easier because they're the ones who are coming and educating my board, educating the public, because I just have to say, hey, look, David, please explain to the public, what's going on here in terms of your application, what we can and what we cannot do. I always advise my boards, it starts with your local law with respect to regulating, wireless services. If you have a good local law, okay, it makes the process, and I know you can probably appreciate it, the better the local law, the better it is for everyone, okay, because it's easy to maneuver in the process. When you have a local law that's not so great, that's when things get a little hairy, there's questions of interpretation, and that's when things can go awry. But when you have a good local law, I've noticed, and maybe you can comment on this too, David, but things tend to go a lot smoother. Right?
Well, that's going to be a huge issue over the next at least 3 to 5 years that we're going to see, is making sure local laws can accommodate these things. Because as I talked about earlier in the opening session, we're moving at lightning paces here. And municipalities don't, period. I mean, it is the most sluggish process. And here you have, entrepreneurs and people who are looking to solve problems. Technology is being developed, and we're just not moving fast enough. And it's not just the planning process. Now, it's the environmental process. I know municipalities have environmental concerns, architectural concerns. How does that all come in play from your perspective?
Well, David talked about the new rule that we have, and there's a component in that rule that allows for, well, let me back up. There's no categorical exclusion for DAS or small cell facilities, be they in the right of way, be they inside a building. What there are targeted exclusions. And so from a federal process, what you have is you have the ability to now exempt yourself from certain requirements, but you first have to subject every facility to some level of documentation to determine whether or not the categorical exclusions that have been granted by the commission with the new rulemaking, whether or not those apply. For instance, we now can put new tower structures within the utility right-of-way, provided that there's no substantial increase over the existing above-ground utility poles, if you will, and provided that other certain requirements are met, so that then at a federal level, you're complete with that process, so that when you go into a zoning or a permitting process, that's out of the question, and then it's up to local ordinance. If there's an architectural review process within the local ordinance that's not preempted by the federal.
But to pick up on Lino's point, yeah, having a good wireless ordinance is important, but to your point about the speed of change, that, I try to build a DAS system on a very high-end area in Long Island, and you're applying DAS to an ordinance that requires a setback and parking at a facility, and you're just, and balloon test for something that it just doesn't work. So you really have to be creative and work with attorneys like Lino who want to work with you.
Yeah, absolutely.
Yeah, and that's key. I mean, I've been through municipalities on the other side where it's not so friendly. You go in and you're met with a lot of resistance, because I think part of the reason is the education's not there. I think they need to be educated on what's going on. I mean, I know in one municipality that I represent, I think we've changed our local law. I'd say within the past 5 years, it's probably been changed about 4 times, which is, in the municipal world, lightning fast, okay? But like David was saying, when you have people who want to work with you, things tend to go a lot smoother. And municipalities know now they have to hire consultants, and with the right preparation, they know what questions to ask, with respect to aesthetics, stealth technologies, and these are things that we can work with together to get a mutual, win-win.
And
solution.
you're a part-time trustee. They meet once every 30 days or so. So
once a week.
you have to get some help on this. I mean, I'll tell you, I also think that we're at a tipping point, that there really is a generational change now. And I'll tell you a story from this DAS system I was doing on Long Island, very high-end area. People started to say, well, I don't want this outside my, it was 500 feet away from the road, their house, but I don't want this on the road because it's going to diminish my property value. And so we got all the experts together to show that there isn't that effect on the property values, and we're about to present to the board. And one of the trustees got up and said, I'm a real estate broker, and it's really not true, because people who are coming in to look at the homes in this area are asking, what's the coverage like? So it's really, we are at this point where I think people are more comfortable with the technology, and we're going to see an easier time.
And so it's really interesting to give you a little bit of insight into the role of a trustee. For instance, I actually meet once a week. There are public meetings that are televised every 2 weeks, and on the weeks that we don't have a publicly televised meeting, we have a public work session meeting that's not televised. But we're also invited to various monthly meetings. The Westchester Municipality group has monthly meetings, and they bring in special presentations. And the last one, I was supposed to leave early because I had another meeting to go to, but I had to stay because it was all about DAS. They had experts come in and educate the municipality government, including those who run in the village manager office and the village managers in the clerk's office, about how to negotiate rights for towers and issues having to do with DAS. And it was really very fascinating. But just like with anything, we're not necessarily the bodies that are making those decisions, nor are the village managers. And a lot of these decisions are being made in the fire departments and the police departments, and then they have to roll up. And it gets to be rather complicated because one hand doesn't always talk to the other, and consultants are always the best, the most highly sought after folks that to bring on to projects because they cost money. But getting access to education by means of attorneys and advisors and volunteer members is really what they rely on, and it's really challenging to work through all of these issues, especially, right, and bringing it back home today for in-building solutions. I mean, we have in-building solutions, which, I mean, yes, you could, you know, we're talking about putting, you know, cell sites out or small cell sites on buildings and, you know, being able to put DAS systems, you know, but what happens with in-building? These are private property owners.
Yeah, I mean, you know, it's not the same as a zoning issue per se, because you're not building, you know, a macro site or a tower or a rooftop. You're installing something within the private property of the owner that needs, you know, a building permit perhaps, an alteration permit, if you will. But you certainly need to do a transaction. You have to have an agreement with the owner and address the landlord's concerns about aesthetics, about you know, who's paying for the power, you know, compensation, if any, a revenue share, if any, who has the burden of building the neutral host, if it's a neutral host system. So you have to have that agreement with the property owner. It's not so much a regulatory issue.
But what about the invisible?
The
It's the spectrum. What about that invisible that we, yeah, you could put some equipment in a building, and yes, you can shake hands and do a deal, but
well, there are people here much more knowledgeable about spectrum than I,
Yep.
but you know, everything has to work together, and you can't interfere with licensed frequencies, and that's, you know, that's the way it's got to work. I mean, you know, in terms of the invisibility, if you will.
And from my standpoint, if it's invisible, it's that much harder to regulate from a municipal standpoint.
That's right.
Because, again, it's not a structure per se that a zoning code would define it, but you might have to go get a building permit for it. But again, those are things that municipalities now have to probably further legislate and change their local
Right.
laws to address that.
Right.
it's really challenging. And who's responsible for ensuring it's FCC compliant once it's in the building?
It's the licensee's responsibility to ensure compliance at the federal level, because that's the trigger that pulls them into the federal process is the fact that the agency has to issue a license. So that on a federal level, it really doesn't matter whether you're inside or outside. You get away from the exterior view shed, but you still have the same requirements, because there are building interiors that are historic and that can be damaged by installation or deployment of wireless technology. So in many cases, you would end up submitting to an agency, say the State Historic Preservation Office, and getting a clearance, but you know, you may be required to modify the placement of antennas or the way that they look in order to preserve the historic integrity or the historic fabric of the building you're installing in.
And I do a lot of transactions for rooftops and other facilities. The most important provision out of, you know, 25 provisions in the agreement is the interference provision. Most important to my clients.
How do we deal with building permits then, and inspections and all that type of stuff with all of these unknowns? I mean, yeah, it's one thing to see a DAS system installed properly and having, you know, powered, you know, correctly done, but how do you know that that's actually been compliant to FCC standards and regulations and all of that?
Well, I think just like planning boards or whatever agency is responsible for the approval, you know, as the municipality, you can request information that you are compliant. You can't regulate it, but you can definitely ask for that type of information. So, you know, for things that would not require, let's say, a site plan approval or a special permit, I guess your building department or zoning official would have to request that information, just like a planning board would or a zoning board would in an application.
Yeah, and you'd know if there's interference, and then you go and look at the license and see who has the actual license. If it's unlicensed spectrum, they can't interfere with licensed spectrum.
Yeah, interesting. We have a couple of wrap-up slides, but before I go there, I wanted to know if anybody had any questions. I can't give you the mic, but I'd be happy to. Oh, we have a runner here. Great, thank you.
Thank you. Jake Raspail, Sublime Wireless. Looking at this, taking its perspective of carriers going into municipality, having done a lot of work in both the smart grid space, municipal wireless space, How does this dovetail with what municipals may put in for their own needs, if it's a smart grid system or a municipal wireless Wi-Fi system, and then also comparing that with what the cable company may do as a area Wi-Fi? I mean, there's shades, sometimes shades of gray when it comes to what's going into the municipality and how it gets dealt with. I wonder what your perspective is.
Very, very much so. And, when we were gas system, on Long Island in these communities, I would say, look, there's a Wi-Fi antenna for this cable system. They didn't come to you. They just did it under their cable franchise, and their cable franchise doesn't talk about antennas. It talks about, fiber optic or coaxial cable. So you're touching on something that's, very, very important. And then, municipalities do want to put Wi-Fi systems in. They also want to have other people, AT&T, Google, whoever in New York City, provide it gratis. But New York City has now turned the payphones into Wi-Fi kiosks going forward. So they're not going to go through it's a public-private partnership and it's going to be franchised, but it's not on the municipality's dime.
Anybody else want to address that? Any other questions? All right, so let's see who's up first.
You want to go to 2 more slides for me? Yeah. So what I'll talk about is just in the new rule that became effective for the environmental portion. David said the 6409 portion is next week. The environmental portion of this rule became effective February 9th. And it offered targeted exclusions. And so just by example, I'll just give you one of them. I've already talked about new structures in utility right-of-way. This one has to deal with co-locating on existing utility poles, so that basically if you meet certain size requirements, for instance, you're allowed to co-locate on a utility pole without having to go through submitting to State Historic Preservation Office, or because it's a federal process, there's an obligation on the licensee, the applicant, to consult with Native American tribes. And so the problem that we had was that we would have an outdoor DAS system that had a certain number of poles. Let's say we had 30 poles and 10 of those were over 45 years old. Well, as a technicality, the carriers were getting caught up in the problem of having to do a SHPO consultation. And whenever you do a SHPO, or State Historic Preservation Act consultation, you're also obligated to go to the Native American tribes. Well, the Native American tribes have fees, so we had poles where there's no ground disturbance. Another entity is bringing in the power and the fiber that you need. So you literally have a small cabinet on the side of a utility pole, cabling up to antennas that are either at the top or somewhere near the top, small antennas. So there's no ground disturbance. There's no possibility of harming archaeology on the license, on the federal licensee side. But some of the tribes were asking $4,000 per node. So what this exclusion does is, if you meet the size requirements, it allows you to avoid having to go to consult with the Historic Preservation Office, and it also avoids having to pay $40,000 or $50,000 in fees where really it's just a technicality and there's no real harm, or very remote possibility that there would be a harm from that type of facility. And this is one of the exclusions.
Did we talk about any of the other slides?
No, I mean, if people have questions, they can come in. We can talk about the various exclusions.
Okay. All right, the 2014 FCC infrastructure report
Okay,
in order.
that's me. Go about 3 slides in.
Section.
Stop there. So this is what the rules are that would, create efficiencies in local review of applications. And again, it applies to co-locations, replacements of equipment, removal of equipment. And if any of these are applicable, meaning there would be a substantial change, it doesn't get streamlined. So what you have in terms of these are, the relevant tests are, is there a change in height in the first one? Is there a change that protrudes from the edge a certain amount? Next slide, please. Are there changes in cabinets beyond the standard? Is there an excavation involved? Or something, or a deployment outside the current tower or base station? And base station is defined to be very broad to include buildings. Does the installation defeat the existing concealment elements? Meaning, would the paint change? Would it require taking away any of the stealthing? And are you adding fencing beyond what was originally, number 6, or beyond what was originally there, unless it relates back to a permitted substantial change? So any of these would bring it back to a more, not as streamlined permitting, and the town could have a more formal zoning review of the change. But what the FCC did is give these localities and the carriers bright line rules so that there are no ambiguities, no interpretations, and that if something comes under these as not being a substantial change, it gets a 60-day look at by the locality, and otherwise it's deemed granted. Very important, very helpful. As I said, the regulatory wind is at the carriers back in these, and the government is preempting, if you will, local governments.
And is it fair to say that because municipalities tend to move so slow, that anything that the FCC does at this point really is what is going to be followed and adhered to on a local level? And so if you know about this or have access to this type of information and leverage this, you can actually accelerate yourself through any kind of local process if you need to.
Yeah, that's it. Okay. It's the end of the day. NIMBY. You've heard of NIMBY. Well, we faced Banana, which is build absolutely nothing anywhere near anyone.
All right, I'm going back. One more. Sorry, I just had to see where I was at.
And you can take the last slides.
Oh, I'm going to go back again.
That's it. Hey, go back.
These are handout materials. You get to read these at home.
And just to pick up where David left off with respect to 64.9, what I said earlier, you should have, as a municipality, a local law that establishes procedures and standards consistent with the limitations established by federal law. So with respect to the new guidelines, yes, local laws now should be tailored to fit the FCC guidelines. With respect to the application, I said earlier, treat it like a site plan with the exception of the timing, obviously. The timing has to be expedited. But when I say a site plan, it just makes it easier for a planning or zoning member to understand that this is the process, but we have to take it through, but again, with certain expedited timeframes. Hire consultants, especially if there is a significant gap issue or least intrusive means. And lastly is don't delay, and I tell it all the time, it's a big thing. That's where municipalities tend to trip up. And don't discuss, RF emissions in a decision unless the applicant hasn't met the federal standards. You're allowed to request it from the applicant, but you can't deny it on that reason. So,
Absolutely.
and that's it.
Well, yeah. Any other questions before we wrap up?
You don't want to be a delayer, or because you will, as a municipality, you will end up in the record at the FCC about why this is a problem nationwide. So.
And then they will adjust all their
And
laws and regulations
they will make it,
in order to
And as a carrier, you shouldn't hesitate to work with, special counsel. The first call, what I like to make is to the town or village attorney when I'm not it. So just to start the process and to get a sense of, okay, what's the environment here? What's the climate like in terms of processing these types of applications?
All right, there we go.
So
We're all set. So we'll take, we're going to clear the stage here. We're going to bring up our last speaker of the day, and then we're going to go into cocktails. So plenty of food and drinks are going to be waiting for us in about a half hour.
So yeah, just one, beyond NIMBY and beyond Banana, there's also NOPE, which is not on the planet Earth. So
That's right. Thank you, guys. Appreciate it.
Thank you.